Monsieur le greffier, appelez le numéro.
Mr. Registrar, kindly call the case.
Thank you and good morning, Your Honours. This is case number ITO 3670, the prosecutor versus Vojislav Šešelj.
Merci, monsieur.
Thank you, Registrar. Today is Wednesday, the 4th of May 2011. Let me first greet the prominent OTP representatives who attend the hearing for the oral decision by the trial chamber under Rule 98 bis. Let me also greet Mr. Šešelj and all the people assisting us, the registrar, the usher, the security officer, and any other people assisting us. Today, I shall start with the reading out of the Rule 98 bis decision, and then I will continue with a partially dissenting opinion of mine. We are to sit in the morning today. We're going to start right now, and we shall more likely than not continue into the afternoon. If I were not to be finished with reading out the decision, we can continue tomorrow afternoon, because I have over 120 pages to read. I shall start. The trial chamber is going to deliver its Rule 98 bis decision, oral decision. Firstly, the trial chamber will recall the procedural background, and then we'll move on to the law applicable under Rule 98 bis. Thirdly, it will recall the counts and modes of responsibility as alleged in the indictment. Fourthly, it will recall the elements of the crimes and set out the law applicable to instigating as a mode of participation in crimes. In a fifth part, it will give samples of evidence it has heard that are enough and capable of supporting at this stage of the proceedings to sustain the allegations as alleged in the counts. And then the trial chamber will review the responsibility of the accused for instigating to crimes as alleged in the indictment through his speeches. First, procedural background. The prosecution case started on the 7th of November 2009 and closed with the testimony of witness Nenad Jovic on the 7th of July 2010. Further on, the prosecution would not rest its case until the trial chamber had ruled on all of their pending motions, including various applications for the testimony of new testament of witnesses, including VS 026, considered as being unavailable for health reasons following a first expert medical report. The trial chamber decided to have witness VS 026 examined by a medical expert, and his opinion confers the first in a report filed on the 26th of November 2010. The trial chamber then ruled on all of the pending motions in December 2010 on all the motions that might have an impact on the Rule 98 bis proceedings by handing down 25 decisions. The trial chamber then had to wait for the filing of the expert report as to the authenticity of the Mladic notebooks filed on the 10th of January 2010, its translation into BCS, and the end of the time limit for the accused to make submissions, if any, as to the motion to admit the notebooks. At the administrative hearing of the 18th of January 2011, the accused informed the trial chamber that he would make submissions under Rule 98 bis. The trial chamber, taking into account the time needed to rule on the motions for review of the decisions issued in December, filed by the prosecution between the 28th of December and the 21st of January 2011, issued a scheduling order on the 25th of January for the Rule 98 bis proceedings to be held on the 7th, 8th, and 9th of March 2011. On the 7th of March 2011, the accused made his oral submissions under Rule 98 bis. He spoke again on the 9th of March in order to reply to the prosecution. Specifically, the accused denied having committed, ordered, planned, aided and abetted or instigated any of the crimes alleged in the indictment. He also challenges and denies having participated in the crimes as a member of a joint criminal enterprise. More specifically, the accused challenged the existence of specific crimes as alleged in the indictment under various counts, as well as their credibility of numerous testimony and other prosecution evidence. Furthermore, he claims that the prosecution failed to lead any evidence as to the speeches in Vukovar, Malizvornik, and Hertkovce, as alleged in the indictment, inasmuch as he did not give such speeches. He further argues that if certain crimes may have been committed, there is no evidence that the crimes should be attributed to the volunteers recruited by his party, the Serbian Radical Party, hereinafter known as SRS. He states that he can by no means be held responsible for crimes allegedly committed by such volunteers, since the accused was not their superior within the GNA in which the volunteers were serving. In conclusion, the accused stressed that it was impossible to prove beyond any reasonable doubt that criminal acts can be attributed to him, and he is of the view that the trial chamber shall therefore have to enter a judgment of acquittal on all counts in the indictment. The prosecution responded to the accused submissions at the hearings of the 8th and 9th of March 2011. It drew the attention of the chamber on various testimony and evidence admitted by the trial chamber, which is such that they would not be capable of sustaining a decision of acquittal. Law applicable further to Rule 98 bis. Under Rule 98 bis, once the prosecution case is closed, the trial chamber must, by oral decision and after hearing oral submissions by the parties, enter a decision of acquittal as to any count for which there is no evidence capable of sustaining a conviction. Since the 8th of December 2004, when Rule 98 bis was last amended, trial chamber is only expected to determine whether the prosecution has adduced enough evidence for each count taken as a whole, as opposed to all the various charges making up that particular count. Rule 98 bis was amended in order to facilitate the proceedings and to provide for a more expeditious trial. First of all, because it moved from written to an oral type of proceedings, and also on focusing on all of the counts rather than on every single crime alleged in each and every count of the indictment. Therefore, since the latest amendment of Rule 98 bis, the trial chamber, in its majority, Judge Antonetti dissenting, deems that it can only enter a decision of acquittal on a single count as a whole. And this is, by the way, in keeping with the practice applied after Rule 98 bis was amended. It was adopted and applied by trial chambers in the following cases, among others, Martic, Mrkšić, Perlić, and Gotovina. The fact that the trial chamber is under the obligation to enter a decision of acquittal on the whole count gives the defense the possibility not to answer to all of the allegations contained in a count for which it feels that the prosecution failed to lead any evidence. Under Rule 98 bis, the trial chamber needs to determine whether there is enough evidence for a reasonable trial of fact to enter a judgment of conviction beyond any reasonable doubt. At this stage, the trial chamber is not to establish whether it would enter a conviction at the end of the trial proceedings, but whether it could do so. It should be stressed that at the Rule 98 bis stage of the proceedings, according to the rules, the trial chamber will first carry out a preliminary examination of the evidence adduced in the prosecution case in order to ascertain whether the evidence is capable of sustaining a conviction. This is a preliminary examination which is different from the analysis carried out at the end of the trial proceedings. Indeed, at the end of the trial chamber must look in depth into the entire case file to examine every evidence on record, be it prosecution or defense evidence, in order to assess their respective probative value. In order to carry out this first assessment, at this stage of the proceedings under Rule 98 bis, the trial chamber must factor in all the evidence adduced during the prosecution case. It is not to make any selection among the prosecution evidence, but the evidence favorable to the accused may only be used to assess whether a piece of evidence is clearly unreliable and incapable of belief. As a consequence, a motion for acquittal will be granted only when there is no evidence capable of sustaining a conviction, or when there is one or several pieces of evidence, but even when taken at its highest, this evidence, the trial chamber could not sustain or decide for a conviction because the only evidence is clearly unreliable and incapable of belief. The trial chamber further recalls that it will only give some examples of evidence. The fact that specific evidence have been taken into account for the purposes of this instant decision does not mean that the trial chamber will assess them in the same way at the final stage of the judgment. Equally, the fact that specific evidence may not be mentioned in this decision does not mean that it will not be taken into account and assessed accordingly at the end of the judgment, in the judgment stage. Furthermore, whilst the accused is charged under various modes of responsibilities, it is sufficient for the majority of the trial chamber judges, Judge Antonetti, myself, dissenting, it is sufficient to establish that there is evidence supporting one single mode of responsibility alleged in the indictment to dismiss a motion for acquittal. Therefore, if a trial chamber accepts one of the modes of responsibility at this stage of the proceeding, does not mean that the trial chamber ruled out the other modes of responsibility alleged in the indictment. Thus, a trial chamber may, when it issues its final judgment, choose another mode of responsibility that was not mentioned at the Rule 98 bis proceedings. The trial chamber further stresses that it is up for the trial chamber to assess the type of responsibility to attribute to the accused on the basis of the indictment and on the basis of the trial record has already been affirmed and confirmed by the tribunal in paragraph 248 of the Kwočka judgment. Finally, the trial chamber wants to make it clear that there is no contradiction between the dismissal of a Rule 98 bis motion and a decision of acquittal at the end of the trial proceedings. This applies even if the defense has not adduced any evidence. Third section, overview of the counts and modes of responsibility as alleged in the indictment. Before I continue, I think I should slow down so that the interpreters can keep pace with me and do their job properly. I'm looking at the English transcript on the screen, and I'm listening to the BCS booth. So far, so good. Third section, overview of the counts and modes of responsibility as alleged in the indictment. The trial chamber recalls that in the third amended indictment, filed on the 7th of December 2007, hereinbefore and hereinafter known as the indictment, the prosecution charges the accused with crimes referred to in the statute of the tribunal, namely crimes against humanity and violations of the laws or customs of war. The charges alleged in the indictment against the accused include the following 9 counts. Count 1. Persecution on political, racial, or religious grounds, a crime against humanity. Count 4. Murder, a violation of the laws or customs of war. Count 8. Torture, a violation of the laws or customs of war. Count 9. Cruel treatment, a violation of the laws or customs of war. Count 10. Deportation, a crime against humanity. Count 11. Forcible transfer, inhumane act, a crime against humanity. Count 12. Wanton destruction of villages or devastation not justified by military necessity, a violation of the laws or customs of war. Count 13. Destruction or willful damage to institutions dedicated to religion or education, a violation of the laws or customs of war. Count 14. Plunder of public or private property, a violation of the laws or customs of war. The trial chamber will examine these counts in two groups as to whether they are alleged as crimes against humanity or as war crimes. The crimes the accused is charged with in the indictment concern the municipalities of Vukovar in Croatia, Zvornik, Sarajevo, Mostar, Nevesinje in Bosnia and Herzegovina, and Hrtkovci in Vojvodina in Serbia. The accused is charged on the basis of his individual criminal responsibility under all the forms of responsibility referred to in Article 7.1 of the Statute of the Tribunal. For all the crimes alleged in the indictment, under paragraph 5 of the indictment, that reads as follows. Interpreter's correction. I'm going to read out paragraph 5 of the indictment, which is a major one. Vojislav Šešelj is individually criminally responsible for the crimes referred to in Articles 3 and 5 of the Statute of the Tribunal and described in this indictment, which he planned, ordered, instigated, committed, or otherwise aided and abetted in the planning, preparation, or execution thereof. By using the word committed, the prosecution does not intend to suggest that the accused physically committed all of the crimes charged personally. Physical commitment is pleaded only in relation to the charges of persecutions by direct and public ethnic denigration with respect to the accused's speeches in Vukovar, Mali Zvornik, and Hrtkovci, and by deportation and forcible transfer with respect to his speech in Hrtkovci, and in relation to the charges of deportation and inhumane acts, forcible transfer, with respect to his speech in Hrtkovci. In this indictment, committed includes the participation of Vojislav Šešelj as a co-perpetrator in a joint criminal enterprise. By using the word instigated, the prosecution charges that the speeches, communications, acts, and/or omissions of Vojislav Šešelj contributed to the perpetrator's decision to commit the crimes alleged. So this was the entire paragraph 5 of the indictment. The trial chamber recalls that if the accused denied any responsibility under any mode of responsibility as alleged in the indictment, this decision will endeavor for the sake of judicial economy, to review the evidence related to the alleged responsibility of the accused solely as regards instigation. Indeed, as we already recalled, in the view of the trial chamber's majority, because I have a dissenting opinion, it is enough for the purposes of the Rule 98 bis proceedings to establish that there is evidence capable of sustaining one single form of responsibility alleged in the indictment to dismiss a motion for acquittal. This does not mean, however, that the trial chamber may not later on rule as to the other modes of responsibility. Fourth section, overview of the elements of crimes and the law applicable to instigation as a mode of liability. With regard to the elements of crimes,
first, the trial chamber recalls that according to Articles 2, 4, and 5 of the statute, crimes of war, as well as crimes against humanity, occur in the context of a domestic or international armed conflict. Secondly, the trial chamber recalls that to constitute a crime against humanity, the actions of an accused must be part of a generalized or systematic attack directed against a civilian population, any civilian population. These two qualifiers are alternative and not cumulative. The qualifier généralisé means that the attack was carried out in a very large scale and resulted in a great number of victims. Whereas the qualifier systematic shows the organized nature of these violent acts and the fact that their randomness is improbable. The systematic nature is recognized through the deliberate and regular repetition of similar criminal behaviors. Thirdly, regarding the actus reus of the crimes, it will be reviewed later by the trial chamber when the trial chamber addresses the counts alleged in the indictment. Fourthly, the trial chamber recalls that the mens rea for each crime alleged in all 9 counts is made up of the criminal intent of the perpetrator of the crime, except for the crime of persecution, where in addition, in order for the responsibility of an accused to be engaged, there is need for a dolus specialis, i.e., a specific intent to discriminate on political, racial, or religious grounds. The trial chamber will revisit this later on when it analyzes count number 1. Section B regarding the law applicable to instigation as a mode of liability. For a trial chamber to conclude that there has been instigation to commit crimes, it must make sure that three conditions are met. First, a condition relating to the elements of instigation. Secondly, a condition relating to the intent of the instigator. And thirdly, a condition relating to the nexus between the instigation and the crime. First, regarding the elements of instigation to the commission of crimes. The case law of this tribunal, notably paragraph 27 of the Kordich and Cherkis appeal judgment, defined instigation as, I quote, provoking someone into committing an offense. End of quote. The case law of the ICTY, notably in paragraph 456 of the Ndindabahidze judgment, defined instigation as pushing, I quote, pushing or encouraging someone else, either verbally or through any other means of communication, to commit a crime with the intent of this crime to be committed. Therefore, as mentioned in paragraph 271 of the Orich judgment, in order to have a actus reus that would make up instigation, the instigator must have influenced the physical perpetrator of the crime by requesting him to do so, by pushing him to do so, or by making sure by some way that he would actually commit the crime. However, this did not presuppose necessarily that the instigator would have originated the idea or would have designed the initial plan in order to commit the crime. Even if the main perpetrator already envisaged the commission of the crime, the fact that he actually carried out his intent might come from having been persuaded or asked to do so by the instigator. More specifically, regarding how the main perpetrator was influenced, there is no need for the instigation to commit crimes referred to by the statute be public or direct, as it is the case for the direct and public instigation to commit genocide, which is a crime in itself and not a mode of liability. As indicated in paragraph 273 of the Orich judgment, the influence coming from instigation can be exerted directly or through intermediaries, and this on a various amount of people, as long as the instigator has the required mens rea. There is no need for the instigator to be on the scene of crime, as stated by the Appeals Chamber of the ICTR in paragraph 660 of the Nahimana Appeal Judgment, which is more well known as the Media Appeals Judgment. Secondly, regarding the mens rea of the instigator, the trial chamber must demonstrate that it is important to demonstrate that the accused had the intent to provoke or to induce a perpetration of a crime, or that he was well aware that there was a real probability that after his instigation, one or more crimes would be committed. In the singular and the plural. In this respect, the appeals chamber in paragraph 32 of the Kordic and Cherkes appeals judgment indicated that anyone provoking another person into committing an act or an omission while being aware that there is a real probability that a crime could be committed during the execution of this instigation has the required mens rea to be held responsible under Article 7.1 of the statute. The fact of instigating while being fully aware of this probability must be considered as accepting the crime that will result. The trial chamber, however, notes that for the crimes alleged in counts 4, 8, 9, 10, 11, 12, 13, and 14, as charged in the indictment, it will be sufficient to prove that the accused was fully aware that there was a real probability that after the instigation, one of these crimes would be committed. However, regarding the crime alleged in count 1, there is need also to verify whether the accused had the intention to provoke or to induce the commission of persecution as a crime aimed at achieving the specific goal of discriminating on political, racial, or religious grounds. Finally, the trial chamber notes that a difference must be made between the intent and the personal motivation. As stated by the appeals chamber in paragraph 102 of the Corneliac appeals judgment, the existence of a personal motivation does not prevent the perpetrator of the crime from having the necessary mens rea. Thirdly, regarding the existence of a nexus between instigation and commission of the crime. As stated by the appeals chamber in paragraph 27 of the Kordic and Cherkes appeals judgment, there is no need to prove that the crime would not have been committed without the involvement of the accused. It is sufficient to show that instigation was a significant element in the behavior of the physical perpetrator of the crimes. Similarly, in paragraph 660 of the media appeals judgment, the appeals chamber of the ICTY specified that in order to have instigation to commit a crime, it is important to establish that the actions charged substantially contributed to the crime being committed. However, it is not necessary for these actions to have been a sine qua non condition of the commission of the said crime. Furthermore, the appeals chamber of the ICTR in paragraph 257 of the Semanza appeals judgment specified that it was not necessary to show or demonstrate that the accused had an effective control over the perpetrator of the crime. In paragraphs 238 and 296 of this appeals judgment, the appeals chamber stated that neither was it necessary for the indictment to state the exact provocative words spoken by the accused or to provide any evidence of it to establish instigation to commit crimes. Finally, in paragraph 368 of the Nchamihigo judgment, the ICTY indicated that the time period between instigation and commission of a crime is also a relevant criteria to determine the substantial contribution to instigation of commission of a crime. As a consequence, the nexus between the elements of instigation on the one hand and the crimes alleged in the indictment on the other hand can be inferred from a number of indicia, taking into consideration elements such as, for example, the position of authority and the influence exerted by the accused over the physical perpetrators of the alleged crimes, or the time period between the instigation and the commission of the crimes or the crime. Section number 5. The trial chamber in its majority, dissenting opinion from Judge Antonetti, will now state why any reasonable trier of fact could conclude beyond any reasonable doubt that in this case, at this stage of the proceedings, there is sufficient evidence to support the commission of crimes as alleged in all 9 counts. First, the trial chamber underscores that the accused did not contest the fact that there was an armed conflict at the time as far as the crimes alleged in the 9 counts are concerned. The trial chamber also notes that the accused even stated about the war in Bosnia that it was both a religious and a civil war. Furthermore, the trial chamber notes that the evidence on the trial record almost all state that there was an armed conflict going on, as far as crimes for humanities are concerned, as well as for crimes of war. A. Regarding crimes against humanity, under counts 1, 10, and 11. First and foremost, the trial chamber would like to answer the submission of the accused who challenges the fact that the crimes alleged in the indictment in counts 1, 10, and 11 would have been committed in the framework of a generalized or systematic attack.